May I please? May I please, Lordship? My Lord, with the consent of the other side, my Lord, I beg to mention item number 15, my Lord. 1 5.
What five?
Yes, my Lord. Look,
I am
item
for
for
the
the day.
appellant, Lordship. I am for
Appellant,
the
right.
appellant. If possible, Lordship, on next Thursday, 7th,
Yes, my
Lordship.
Lord.
On next Thursday, Lordship. 7th, Lordship.
7th of August.
Now there are two benches, Lordship. No,
hearing matter.
hearing matter. Affected by Lord.
Highly obliged.
May I please, Lordship, I beg to mention item number 14. 14.
Item number
14.
what for? Here also I am for the appellant, Lordship.
Only take the matter.
Take Lordship on 4th of when? 10 days. 10 days. The secretary by Lord and advocate to put the part on 4th of Obliged.
May I please, Lordships. One, my Lord, my main RSA was dismissed, my Lord, for default, my Lord, and I have filed a IA, my Lord, for restoration of the same, my Lord. And matter was, my Lord, last listed on, my Lord, 28/5, and thereafter we have taken steps, my Lord. But what happened, my Lord, in the executing court, my Lord, the case has been fixed on, my Lord, 8th of August for order, my Lord.
So
That's why, my Lord, I am praying.
The matter in the court number 8.
My Lord.
Court number 8.
Obliged.
May I please, Your Lordship? With the consent of the petitioner's counsel, I beg to mention item number 17, Lordship.
What's that?
17. And maybe adjourn, my Lord.
When can we
So 3 weeks. 3 weeks.
Why? Why?
Instructions are awaited by the respondents, Your Lord.
You are for
Respondents. Respondents, Lord.
You inform the other side?
I have taken consent, Lordship. I have taken consent.
Okay. Mr. Your good name?
Why Borhuya?
Learned counsel appearing on behalf of
Mr. H. Gupta, London CGC.
Mr. H. Gupta, learned counsel for the petition with consent to the other side. Plus 2 weeks.
2 weeks. Lordship, interim order is there. That may be.
They are allowed to order password.
Much of it.
May it please the Lordship, I beg to mention item number 12. We have also taken the consent from the other side. Kindly list the matter after 3 weeks.
Your good name?
Q. Roy, appearing on behalf of F. Begum.
Appearing on behalf of
F. Begum.
Lordship, a date may be fixed for that.
Okay. That's right for by learned as agreed by learned that to put the part on
May it please the Lordship, I beg to mention 1 IA and MSc appeal for listing under order column.
court number 8.
May I please, with the consent of other side, Lordship, I am mentioning the item number 16, Lordship. I am for the respondent, Lordship. For a password for a day, Lordship. 16, Lordship. 1 6. 1 6.
Lordship, no objection.
Okay. That's agreed by learned that to
Lordship, a date may be fixed.
the matter on
Obliged.
Obliged.
Yes, please, Lordship. Lordship, I beg to mention item number 11 of today's list, my lord. Actually, my senior Endega is suffering from the, my lord, severe back pain and vertigo, my lord. So he is unable to present before today.
number 11.
11, my lord.
Mr. Your good name?
V Vaspor, Vinod Vaspor.
V.
V Vaspor, Vinod Vaspor.
Learned counsel appearing on behalf of
Respondent, my lord.
respondent.
Endega, my lord.
Your name is not there.
Not there.
You are appearing for
On behalf of Endega, my lord, my senior.
Enteka. Learned counsel for the respondent. You obtain consent from the other side.
Not my lord. No, my lord. Lord, I have not been there.
Okay.
Consent, my lord.
With consent from the other side, that's what the matter when
My lord.
when
My lord, after 3 weeks, my lord.
after there.
May I please, your Lordship? I beg to mention for listing of a civil division petition, Lordship. It was last listed on 6/8/22.
Number 8.
Court number 8. Calculation दिया तो mediation में देखो, but not necessary. It's a hard not can doctor. The mediation in a palai recovery interest can over it. What the calculation के दिया तो ना हुए जो हम calculation की
This matter, perhaps we have heard.
Your Lordship have heard it. Heard it only the calculation. We have submit our calculation. They have to submit their calculation. That's all, my lord.
They have submitted your
My lord, we haven't submitted yet. Their copy also we didn't receive. No, copy did this. Earlier, they made wrong calculation. Last time they gave, that calculation was wrong. We told them to make it correct and give it. No, this is given there. Why you are arguing on that? No, I'm giving it.
Last time, my lord, that calculation was totally wrong. That's why I requested my learned friend. Make it correct and then place it.
No, my lord, if he says so, my lord, to my knowledge, I have given him, but however, today I will submit.
Corrected one.
Corrected one, yes, which I have submitted before the court.
Because that's why, my
Yes.
lord, let's do one thing since it has come in the, for reference to the mediation. It can be sent if we can make it okay, then it's all right.
No, my
With
lord,
the same calculation. if we-
again, my lord, mediation, my lord, again, this disagreement will be there, my lord, regarding the enhancement. So
No.
it will be better, my lord, if your lordship has
What
the
my
judgment.
management is thinking, so far the calculation is concerned, future prospect, all these things are legalized now. So the insurance company cannot, my lord, say that we shall not accept that. If they refuse, my lord, your lordship is there. I'm
So
not,
again, it will
I,
come back to the
I'm
square
not
one.
trying to say that if it is go to mediation, they will get lessons. It's not the idea at all. Because the endeavor of the insurance company also, by this honorable court, also, my lord, that we want to dispose of the cases as much possible in the earliest.
better you one thing. What are they? You furnish a copy.
Yes,
Yes,
my lord, I'll furnish the
corrected copy, let them furnish.
Then you will hear the matter.
Right.
Yes,
Suggested that
I will give a copyright today, my lord. And the date may be fixed, my lord.
Next week, anytime, my lord.
back to it.
Next week as a part hard matter.
And also furnish- That's one. So the matter has listed under the column for referral to the state drive. That's my pitch. For the next year, it appears that matter has heard by this court. And according, it's provided that the matter
13 August as a part hard.
as part heard.
Much obliged.
Oblige you. It's opportunity.
Yani for respondent number that number 5.
Number? In this case, the matter has been heard. Both of us are supposed to provide the calculation. Only calculation. We can still do it. It means central calculation, if our calculation, matter was hard.
Matter was hard and only calculation part is my lord.
If we both agree to the same, then.
No, it's court heard this matter.
Honorable my lord Justice Madam M. Nandi, now retired. Madam M. Nandi, now retired.
This court had not heard it, Lord. Not by this court.
No, Madam Nandi.
Court is also not.
It's the
It can
matter
go
of- oh, hearing here. Will hear the matter here.
My lord,
Will not refer.
my lord.
Or do you want it to be referred to the magistrate?
My lord, maybe fixed another date for hearing, my lord. Only this part, my lord, calculation part. Without mediation, my lord, this matter
It
may
has to
be.
be heard again. This court will have to hear it again. That was heard
Then,
by another court.
Maybe referred mediation.
No, see, let me refer to mediation. If we fail, we'll immediately.
No, is there a chance?
But that was so such a long time.
Interest part will consider, my lord, it will be, there will be a chance, my lord.
2016 matter,
Sent
therefore,
for mediation will.
No.
Not say it must be sent for mediation.
magistrate,
ये अलग अलग मुताबिक है।
also the- Your name, please.
M. Islam,
Name Islam. Your name.
Doctor,
claimant.
It entered is the mistake under the column
Well.
10. Alerted to the part. That better the part. Next. According to the comparison, the part what the that's the method negative the parties have appeared on
Well, for date maybe.
8 of August.
Mother.
8 of August.
এটা আমাকে প্রথম
90th. Here,
Regular.
the part report.
জানি this has to go for hearing. These are policy defense methods.
Pardon?
These three cases will have to go for hearing.
Hearing. Okay. Thursday then.
My lord, in August, my lord, September, my lord, 9 September,
9th of September.
9.
September is also all right.
11th.
So after September.
Then, my lord,
18th of March, it's about
18th September.
no, 18th of
18.
18th of any day.
18.
18th of any day.
18 after 18. Then 23rd, my lord.
Okay.
Highly obliged, your lordship.
Right.
Also, by applying for the respondent number 3, the delay has not been pointed, and the appeal memo is not with us, so we don't know the ground. Respondent number 1 has expired, I think. There's a office note.
Respondent number 1.
1 has expired. Office note is there. 29/7, recent, 2 days back. Okay.
My lord, condonation of delay for petition was filed for condonation of delay. I was not. I am.
I is for
Condonation of delay.
Delay condonation.
Delay.
Condonation of delay.
why the matter is pending in the Southern
Your lordship, respondent number 1 has expired in 2013, office note.
of the
2023 itself only. But they have not substituted, so the matter may be pending. Last office note.
and in respect of respondent number 2, Vijeswar Punya.
Someone has 2 years appeared, I lost. 2 and 3 years appeared. I am for 3. Yes.
Who appeared.
2 years also appeared. Yes. The Wakatna in the costly is given. Number 2 years.
When of you take necessary to get the legal affairs of the respondent number 1. Third is your good name, please.
And Dr. Sharma.
Pardon?
N.D. Sharma.
ND Chorn. Third is,
A Acharya
after
for respondent number 3.
or 3.
3.
Office noted number office not one for then suffered by provided that the of that the heir of the
One.
the of the which
Public.
That may be fixed, my lord. That may be fixed.
Public.
Item number 7 and 8 is analogous matter. The petitioner before the lawsuit claiming for a year's salary from 16/10/2015 to 14/7/2022, my lord. The petitioner,
part
it is my BTC is
BTC.
BTC. On earlier occasion, B. Chaudhary was B. Chaudhary.
Okay, after some time,
Yes.
the court master will inform you.
Yes.
Item 8.
Is a lot. This matter, I pray that matter be passed over for the time being, my lord. My senior is taken up after some time.
That case, your lordship kindly take it up at 2.
No problem.
Yes, my lord, because both of us, my lord, we are having some other matter.
But the problem is that we have no matter in the list. Okay, anyway, at 2.
Yes, really.
very ভালো না?
Please, your lordship. Lordship, matter may be taken after some time, lordship. My senior is in another court, lordship.
But we don't have matter now.
Lordship, the IA, the present IA has been filed for substitution, your lordship, of the appellant number 4. However, I could not find the delay condonation petition and setting aside abatement because the appellant expired in way back 2016, your lordship. Only what has been filed is the substitution petition here.
Much of.
My pleasure, Lordship. Today I have received copy of objection yesterday, Lordship, filed by the
Yes, sir.
respondent.
Yes, Lordship, we have filed an affidavit yesterday only. Please kindly give some chance.
But the
M.K. Neu.
NK
M.K. Neu.
name learned to the your
General.
name,
P. Roy.
please, Roy, on learned that filed by the content yesterday. And read granted like nothing. Yes, they allowed is the
After 15 August.
after 15.
September. 11 September.
Lordship,
Lordship, on the last occasion, I informed the
Lordship, that similar matters were heard by Justice A.D. Chaudhary, and Lordship, judgment has been delivered. Lordship, it's in the paper. Lordship may not.
In that matter, some of the candidates who did not receive the salary from 2015 till date, and some of that claiming from 99. Some of received the salary from 22 to 29. So my case is that the petitioner was reinstated in the strength of an order, my lord, which is passed by the director of BTC. And they were, after joining in the state post, they were continuously working in the state post till 2022. And in that period, how they can deprive their regular salary, my lord?
Lordship, from paragraph Roman 18, Lordship, it has been held that after discussing everything, that every incumbent who were regularized again in 2022, they will be entitled for our salary from that day onwards, not from 2015 onwards. And here, precisely, the petitioner is claiming area salary. See, the petitioner is also regularized in 2022, and first regularization was in 2015. From 2015 to 2022, no one will be entitled for regular salary since they were regularized against non-sanctioned post. Subsequently, Finance Department has sanctioned the post, and as per the memorandum of settlement, creation of a post, the power is completely with the state government. Only after creation of a post by the state government, then only the BTC authorities can make the necessary appointment.
But here, my lord, lordship,
No, it is your case that earlier regularization was again non-sector.
Yes, Lord. Non-existent post. Pursuant to the lordship, initially they were most of the petitioners in those cases also, they were terminated being illegal appointment, and those termination were challenged before this honorable court, and honorable court upheld those termination since they were appointed against non-existent posts and without following the recruitment process. Subsequently, they went on appeal lordship, where the BTC authority gave a statement and in affidavit also that a policy decision has been taken to withdraw the termination order and regularize such teachers. Subsequently, in this judgment, it was found that lordship, the policy decision was without the sanction of the Finance Department of Government of Assam, and so and the policy decision of the Executive Council was in respect of a particular number of teachers, not all of the terminated teachers. And the direction, it has been elaborately discussed, lordship, and the direction given by the division bench was taken to be the decision to implement that policy decision was taken to be as a direction by the BTC authority, which was a wrong assumption, but it was found that only it was confined to 221 teachers. So subsequently, though Finance Department has given approval for creation of posts and sanctioned it, from 2021, many of the terminated teachers were regularized. And so from the date of the creation of the post and subsequent valid appointment, they will be entitled for the salary. It was held by the coordinator. Lordship may peruse that order and Lordship may fix it some other day so that.
Sir, this judgment will cover the present.
Yes, my lord. Yes, because Lordship may kindly look at the prayer of the petitioner.
I'm praying for only area salary, madam, for a
Page 16, Lordship. Page 16, it is therefore prayed that your Lordship would be pleased to admit this petition, call for the record of the case, issue rule calling upon the respondent as to why writ in the nature of mandama, chasuri, and or any other appropriate writ, order, or direction shall not be issued to release the area salary of the petitioner from 16/10/2015
till date 14/7/2022 in Pub Nalbari Balika LP School, which is amalgamated with Navin Kumari ME School in the same campus after reinstated in a post on 16/10/2015.
Where is the regularization order? First regularization order?
Annexure 12, page 36, my lord,
Annexure 12.
where it is clearly mentioned.
Sir, so today,
Yes, ma'am.
what is your environment in your affidavit regarding regarding regularization against non-existent post?
Folks.
This affidavit filed by the respondent number 4 is the affidavit.
Yes,
of
ma'am.
the-
Yeah,
Yes, ma'am.
yes, my lord.
Where is the environment?
Lordship.
No such environment, my lord, made in the affidavit, my lord. I have gone through the environment.
Lordship, it will be, it starts from page 51, bottom, Lordship. Read table number, Lordship has.
Yes, 182.
182, the BTC authority by an order dated 16/10 issued on the memorandum so withdrew the termination order and reinstated the petitioner in her respective school, Pub Nalbari LP School, by its office order dated 16/10 with prospective effect. However, it is pertinent to mention that the reinstatement of the petition so made was not against any substantive cause.
So, madam, have you filed any reply to this affidavit?
Not filing any reply.
Not filed. This department uncontroverted that was regularized against non-existent.
In the state regulation order, there is no mention whether they were appointed in a substantive post or not. They were simply stated that they were regularized and reinstated in the post of assistant teacher. On the strength of this order, they have joined, and here, as I am speaking, talking about item number 7 and 8, because they have joined and they have quite under dark that their appointment letter for regularization was in a substantive post. If it was a substantive post, the petitioner came in to know that they will not get any salary. But they were completely dark about that. If a government order, on the strength of a government order issued by a director of education, and they have joined and they have continued till 2022, how they can deprive their regular legitimate claim for salary?
So today, you say, even if it is accepted that they have been engaged, no, they have been regularized against non-action, non-existent, but even then you have utilized their service.
Lordship, that aspect has also been dealt by the coordinate bench, Lordship.
Maybe.
Lordship, then she has to distinguish that her case is different from the judgment delivered by the coordinate bench. Lordship, it's not a case of 2 or 4 petitions, about 200 something, 200 something, Lordship, in 40 cases. Lordship, coordinate bench has gone into details of each and aspect stage of first regularization, that is in 2015, then second regularization in 2022.
But that may be stated in the first regulation order that this post we are going
Similar order were given to the petitioners also. That also has been
getting salary because the post is not substantive post, but that were not mentioned. And they are the simply they have understood that this is a government order. We are following the order, and accordingly they join in the service.
No, Mr. Sorry, you see, come to annexure number, the first appointment order. That appointment order was against the section 4.
Against the regular. When is the sanction code? It is in 1990.
Lordship, if that is sanction post, Lordship may kindly turn over to page 25, annex of 5. Then why it would have been converted again to or upgraded?
Annexure?
Annex of 5, page 25.
Yes. Yes, that is converted to non-claim post.
Non-claim.
Created by letter number 12.
Just to Lordship, then why, if it is against sanction, but Lordship, she has to distinguish the judgment of the coordinate bench because it has dealt with every aspect. Lordship, simply, Lordship can also not ignore that judgment because
No, I am not telling that I am ignoring that judgment. The facts may be different from each case, from case to case.
Case to case, yes.
Lordship, if Lordship goes through the judgment, Lordship, similar facts. In some cases, some are claiming from right from their initial appointment before first regularization. In some cases, some are claiming from 2015 onward. And some are stating that since 2015 we are regularized, how we can be again regularized in 2022. 3 issues were there, Lordship. And second issue, it covers the petitioners also.
Maybe their first appointment was not in a sanction.
Not maybe, Lordship, on the basis of the facts dealt by the court, she has to distinguish her case, Lordship.
And they were also terminated in 2009. After writ appeal, they have reinstated and regularized. I am claiming only that period, my lord. After regulation, though I have after regulation, I am continuing in my post. So I may be received the salary from 2015 to 22. That period, long period, 6 years, some 4 months, 6 years, so 4 months. If any direction by the state of Assam to the BTC authority, though you have to regularize those shares.
No, No, Mr. Supre, the first order dated 4/12/1999 against the family. It is indicated in the letter. And this regularization is this conversion of the post to non-plan. That is also against the sanction. The regularization, the first regularization may not indicate against any post because termination order was withdrawn. Withdrawn means the earlier order
Termination order withdrawn, Lordship, but it doesn't say against which post.
termination order withdrawn means she will be reinstated against the earlier post.
Yes.
Even then, Lordship, the condition subject to the condition, the first condition, it shall come into force with prospective aspect. But it was against without any sanction post, Lordship. If there is no post, from where the authority will get the fund?
Where the earlier post done?
Lordship, that was also against non-existent post. That has been established in each of the cases, Lordship. That's why in the earlier Jagannath Day case.
No. Mr. Supre, see whether you have made any averment in your affidavit that these two orders are illegal or arbitrary, or it is against non-existent post.
Lordship, I have read it was against non-existent post.
Where you have made such a
Annexure, Lordship, page 52. However, it is pertinent to mention that the reinstatement of the petition also made was not against any
line they were dating.
page 52, first paragraph, Lordship.
Yes.
And in the next paragraph also, we have stated that BTC authority cannot create any post on its own without the sanction of the finance department.
So, you say one omnibus statement was made, but where is the specific department that these two appointment orders are illegal and arbitrary and against non-existent?
Lordship, 99 appointment we cannot say because BTC was not formed at that point of time. It was the state government.
That argument you cannot advance.
Lordship, subsequently when BTC was formed, Lordship, we found that those were illegal.
These two annexures, annexure number 2 and 5, you have not challenged it. Anyway, madam, you please go to the judgment then delivered by the statement and leverage it put on accept whether your case is 36 with the of this. And the Supreme,
Yes,
you bring this order judgment on record by our Uddar Burga attorney. The respondent big number, respondent number.
Lordship, for the BTC authority. Chief Highway.
And yes. For respondent number 1 and 2, and
Miss R.M. Barua for respondent 3.
for during the course of hearing, Sir Secretary has brought the notice of court a judgment delivered by a court in the bench of the court in WBC number 6 of 2017.
Lordship, there were similar other cases also. Since it was a voluminous one, Lordship, I just took out the first page and the decision given by them.
Brought the court that for while dealing with officers, the present petitioner uh, said and that the present petitioners are also covered by according to this provided that the record judgment is protected by the court. WBC with by filing it it take the seek record of the of, 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 of one when this one
Mm. 32.
20
May I please, Your Lordship? Lordship, 2 weeks time may be granted to file a condonation petition and a setting aside amendment petition.
or that
M. Hussain,
learned doctor appearing above that
Arali.
are applicant that my certificate application ordered when of that filed by the applicant there for died RSN or but I learned that the number 4 upper demand in the year 2016 and though it's a quite also here yet the big that abatement setting aside of abatement of five learning of and time five for delay setting aside the abate that is accordingly allowed with the method after
Deeply.
May it please the Lordship. Well, this IA has been filed by the Register of Trade Union for cancellation or for setting aside of the interim order passed by your Lordship. Now, what happened? The registration of the petitioner was cancelled. And Lordship will recollect this matter was somehow placed before a Lordship on the last occasion on 15. The cancellation was due to the fact that they submitted forged and fabricated document of the minutes of the meeting. And when it was detected, and it was subsequently cancelled after giving all notice, opportunity of hearing, propose everything. Now that appeal is pending before the Labour Court. Now initially Labour Court passed a stay of interim order. That order your Honor will find at page 86 of the IA.
Page number
86. It starts from page 79 at the operative part. Initially, there was an interim order. My lord, 86 of the CRP 85 of 25. And it was an ex parte interim order passed. CRP 85 of 25. '86. The registration of the union was cancelled. Petitioner association was cancelled on 30/8/2023 by the Register of Trade Union. And the operative part at page 86, last paragraph. Before going to pass an order on merit of the appeal, I am of the view that considering urgency of the situation as the appellant are to take part in the ensuing election process of the National Trade Union meet. For the sake of justice, the operation remains stay. Now, trade union meet. It was on a totally wrong appreciation of basic facts. What happened? They are not the member of any registered trade union. They are affiliated to a central body, which is also a society. I'll take your lordship to that. So that stay order was operating, and then in the meantime, the matter came to the High Court on a different issue, and ultimately the stay order was vacated by the Labour Court after going through our objection for filing for vacating the interim order, and that order is under challenge before your lordship in this year. Now, if your lordship takes off my IA, lordship will see that on 12/8/2018, this particular association had a meeting that minutes of the meeting is at page 18 of my IA. Now, in this meeting on 12/8/2018, it was resolved to form one association and get it registered by under a trade union. At page 19. On the same day, a different meeting was held, which your lordship will find at page 23. Now your lordship will see that the meeting resolved to appoint one Jitu Bormon at serial number 8 as secretary of the association. And at page 24, your lordship will see meeting also adopted a resolution to register the society. So in that 12/8/2000 meeting, it was resolved to form a society and get it registered under the Societies Act. The lordship will come to page 24 and the first paragraph. Meeting also adopted a resolution to register the society under the Society Registration Act.
Yes.
Now, pursuant to this resolution under the of 12/8/2018 to register it under the Societies Registration Act, the association files an application before the Register of Societies. That we have made a statement which we were not initially aware of. It was submitted before the Register of Society on 5/10/2018. Lordship may take the note, and I will take your lordship to that part, which is 5/10. Resolution adopted on 12/8/2018, that is August 2018, 12th August 18, and application for registration under the Societies Registration Act was filed on 5th of October 2018. But it could not be registered because of certain reasons, primarily which we could get to know that the secretary was having a criminal case pending against him. Now, what they have done, if your lordship takes up the name of the persons attending the meeting, the same person, same serial number,
Yes.
Now, having failed to get any registration under the Societies Registration Act, this association submits an application before the Register of Trade Union on 27/2/2019, 27th of February 2019. By annexing or placing a resolution dated 12/8/2018, which your lordship has already seen at page 18, that the association decided to get it registered under the Trade Union Act. Based on this resolution, registration was given, and registration number 2818 dated 25/6/2019 was issued to the writ petition. Subsequently, one Mr. Abedullah, who was present in the meeting wherein it was resolved to get it registered under the Societies Registration Act, brings it to the notice of the Register of Trade Union that they had manipulated the minutes and got it registered. What they have done, they had maintained the list of the members attending the meeting, the signatures are the same, but they have changed the resolution, which your lordship has seen at page number 18. Mr. Abedullah has also placed before the Register of Trade Union that application was filed before the Societies Registration Act on 5/10/2018. Now, having come to know, the register issues a notice, show cause notice on 12/5/2003.
Well, 5
2000, I'm sorry, Mala, 23. Now, another aspect lordship will kindly take note of. Lordship may come to page 31 of the IA. This is the constitution of the association submitted before the Registrar of Trade Union. Page 31. Now, 1, the very first line, the name of the society, Chemist and Druggist Association of Assam. Now, this was submitted before the Registrar of Trade Union along with the application. Now, if your lordship comes to the notice, show cause notice dated 12th of May 2023 at page 44. Whereas the office exercising powers conferred by the Trade Union Act has registered so and so 44 or 44 of the IA. Whereas the office exercising the powers conferred by the Trade Union Act 1926 had registered the Chemist and Druggist Association of Assam as a trade union under Trade Unions Act, registration number 2818 dated 25/6/19. The following issues have come to the notice of the undersigned. That before applying for registration under the Trade Union Act, the association has applied for registration under the Societies Registration Act 1860 on 5/10/2018. Enclosing one memorandum of association, minutes of the meeting of the association held on 12/8/18, together with signature of the person attending the meeting, wherein it was resolved as to register the association under the Societies Registration Act, and the application is still pending. The association has not disclosed this fact with regard to the pendency of the application before the Registrar of Firms and Societies to the Registrar of Trade Union with in any point of time. They seem to have suppressed this material fact, hence misleading our office to derive the registration under the Trade Union Act fraudulently. Number 2, your association, while applying for registration under the Trade Union Act, enclosed the minutes of the meeting held on 12/8/2018 containing signatures of same persons as enclosed in the minutes of the meeting dated 12/8/2018 submitted before the Registrar of Firms and Society. That the date of the meeting was same and the people attending the meeting were same, but the resolutions were different. There seems apparent manipulation, fabrication of documents, which has resulted in issue of registration of certificate under mistaken bill. Now, this is the show cause. Now, if your lordship comes to page 49, their reply, I'm just drawing your lordship's attention to the aspect of two different minutes. Now, page 49, first D, it is stoutly denied. It is the reply to the show cause notice by the petitioner association. It is stoutly denied there was any manipulation in the copies of the resolution filed while applying registration. Pertinently, two separate meetings were held on 12/8/18, which can be gathered from the venue and time depicted in the resolution. Though initially there was some difference of opinion among the members whether to obtain registration as a society or as a trade union, it was eventually decided to pursue with the resolution adopted on 12/8/18 at so and so, that is the resolution to register the organization as a trade union after the members understood the purport of section 14 of the trade union. Now, my lord, the difference is there are two meetings. Initially, there was a difference among the members. So, we had ultimately decided to go for the registration of the trade union. Now, for a moment, lordship will appreciate one thing. If that is the reason, then why they had earlier approached the Register of Societies? Meeting was held on 12/8/2018, but they approaches the Register of Society on 5/10/2018. Having failed to get the registration and that application was pending, it is only on 27th of February 2019 they approaches the Register of Trade Union. So this shows that there was some manipulation, because till date, even in the labor code, several opportunities were given. They could not produce the original minutes of both the meetings and the signature of all the persons attending both the meetings. Everywhere the minutes are presented, but the signatures of the persons are same. Even, my lord, there is a serious coincidence. All the persons attending are same and their serial number are also same in both the meetings. This burden of establishing that there was no manipulation of documents could not be discharged by the association. As a result, that registration was cancelled. Against that, appeal is pending. Section 10 of the Trade Union Act says that if the registration of an association is obtained by fraud, then it can be cancelled. Lordship may have a look at 10 of the Trade Unions Act. A certificate of registration of a trade union may be withdrawn or cancelled by the registrar A on the application of the trade union to be verified in such manner as may be prescribed. B. If the registrar is satisfied that the certificate has been obtained by fraud or mistake, or that the trade union has ceased to exist, or has willfully or after notice from the registrar contravened any provisions of this act, or allowed any rule to continue in force which is inconsistent with any such provision, or has rescinded any rule providing so and so, the registrar may cancel it. Now, if the registrar is satisfied the certificate has been obtained by fraud, so the registrar was prima facie satisfied it was obtained by fraud because they could not produce the original minutes of both the meeting to satisfy the registrar that in fact 2 meetings were held. Initially, the registration was given considering that 12/8/2018 meeting to be a genuine one. When Mr. Abedullah brought it to the notice of the registrar, then for the first time the registrar comes to know that yes, there is something wrong and something fraud has been committed, which has resulted in issuance of the registration certificate. That is why the registrar has issued a notice, which is a requirement of the statute, that one cannot cancel a registration without giving a notice, a 60 days notice. My lord may come to, provided that not less than 2 months previous notice in writing specifying the ground on which it is proposed to withdraw or cancel the certificate shall be given to the registrar of the trade union before the certificate is withdrawn or cancelled. So there is a compliance of this provision. The notice was given. They were given the opportunity to explain the circumstances which they could not establish, and that order was cancelled. Now, this is a case where an appeal is pending. During the pendency of the appeal, they had filed an application for keeping the order under stay. Initially, there was a stay, but subsequently the labor court, having prima facie satisfied that yes, you could not meet the requirements of make out a prima facie case by producing the minutes, vacated the stay order. I will take your lordship to that part. And another aspect which is very important so far this case is concerned, lordship may come to page 52. It is the memorandum of the parent body. This is All India Organization of Chemists and Druggists, of which the present association is a member. It is an all India body. Now, this all India body is a society. Lordship will see, this is their application to the Register of Firms and Societies. Registration of the society, this is name of the society, All India Organization of Chemists and Druggists, and registered number of the society is so and so. So it is not a trade union. The All India body is not a trade union, of which they are member. And if a lordship comes to page 53, lordship will see the membership requirement. There shall be 4 classes of members as under ordinary members. We are concerned with ordinary members at page 53. Any state, union territory, chemist and druggist association is eligible to become an ordinary member, provided in the opinion of the executive committee it has got adequate verifiable number of chemists and druggists on its membership roll or in the membership roll of its affiliated district association, so as to project it as a representative body of the state, chemist and druggist. The organization shall enroll only one ordinary member in one state. Each member will have to submit their registered memorandum. Now, my lord, here the requirement is not that it has to submit a registered certificate under the Trade Union Act. They are required to submit a registered memorandum and regulation which will be kept both in the operating office and in the registered office of the association. So, their requirement is to submit, to be a member of the parent body, all that is required is to submit a memorandum, registered memorandum and registered regulation. It is not that they have to be registered under the trade union. Now, they initially go for registration under the Societies Registration Act, but could not because of certain factors. They manipulated the record and got themselves registered under the Trade Union Act. That has now been cancelled. Now the question comes whether this cancellation will lead to cessation of their membership. It is not. Lordship will appreciate one thing, the requirements of an interim order or an injunction is not a matter of course in an appeal proceeding. 3 things have to be established. One is a prima facie case, 2, balance of convenience, and irreparable loss. These are the 3, if I am not wrong, my lord, these are the 3 requirements for an interim injunction or stay in the appellate proceeding. Here is a case where they have failed to make out a prima facie case that in fact 2 meetings were held and they produced the originals of both the meetings. Had they produced both the minutes in original before the labor court or the register, then it could have been prima facie established that yes, there was a meeting and the cancellation was wrong. Now, here the registration under the Trade Union Act is not an essential requirement. They still continue to be a member. And balance of irreparable loss, so far it is concerned, Lordship is aware that if they succeed in the appeal, the registration will be restored. I am just wanting one example, my lord. If a person is dismissed from service, he approaches the court. My lord, dismissal from service entails a civil consequence. But everything is restored once it is established and the dismissal order is set aside. A dismissal order is never stayed in the interim manner, allowing a person to continue in the service. Here also it is somewhat similar.
No, Mr. Chakraborty, on that day, whatever documents were passed for considered those documents and considering the interim was granted.
No, now the question, no, these facts that they had manipulated the document, both these resolutions were not placed before a lordship.
Yes, not placed.
My question before a lordship, what I'd like to press before a lordship or a determination by a lordship is whether the labor court, appellate court, exceeded its jurisdiction or failed to exercise its jurisdiction while vacating the interim order. That is only when your lordship under 227 exercises the jurisdiction. Not in cases where your lordship finds that a different view is a possibility. It is only when the court exceeds its jurisdiction or fails to exercise its jurisdiction. It is only then a 227 court.
That day, no notice was issued to you.
My lord?
You have not been heard on that.
Yes, on that day we are not heard.
Yes.
That is why I am before your lordship for
Okay, all right.
I am before your lordship for getting that interim order vacated. Now, these are the facts where it shows that,
Okay, all right.
and my lord,
Yes. Mr. Tekka, what is your submission?
my lord, I'd like to rely some.
No, not necessary.
And before, but I'd just like to point out the operative part of the order which is under challenge and how the Labour Court has explained. Lordship,
That is part of the record I will pay.
now the Labour Court has given a reasoned order.
Okay, all right.
Labour Court has exercised its jurisdiction.
All right, we will say it.
Well, before your lordship hears Mr. Tekka,
Yes.
may I just make some of
Yes,
submission?
yes.
My lord, certain decisions, my lord,
No, not necessary.
which says that High Court can interfere in cases where there is fundamental error.
Sit down. Yes.
Well, the only thing on the basis of which it has been our case that the interim order needs to be vacated. Although, my lord, we have not filed a separate application. But since we are also party before your lordship, my lord, I am just advancing the submission. The basic crux of the matter is that, my lord, the registration of the trade union was taken by showing some resolution in support of which there was no decision, no agenda, no proceeding was drawn. Now, how that is made out, my lord, if your lordship, in the IA, if your lordship will kindly see, in the IA, if your lordship will kindly come to page number 23.
Yes.
Now, in this page 23, your lordship will find this is the agenda of the meeting, which was produced before the registrar of the trade union. And based on this, it was contended that we have resolved to form a trade union, please grant us registration. Now, kindly similar the time and date. It is 12th of August at 3 p.m. Has your lordship seen that? Now, in support of this resolution, my lord, an attendance sheet is annexed. Now, kindly see that attendance sheet, my lord, that is at page 28. It starts from page 25. It starts from page 25. Now, if your lordship will kindly see page 25, just below the writings 25, my lord, your lordship will find the impression Hotel Minerva. So, it is the attendance sheet of Hotel Minerva. If your lordship by now has seen, my lord, on the same day, 2 meetings, as the projected case goes, on the same day, 2 meetings were held. 10 a.m. meeting was held at Minerva Hotel and 3 p.m. meeting was held at Baninagar, Riyavari. That is the case of the appellant petitioner before your lordship. Now, what they did, what is the manipulation, my lord? In support of the resolution that was shown to have been taken at Baninagar, my lord, they enclosed the attendance sheet of the meeting which they organized at Minerva Hotel. Page 25, your lordship will see the writings Hotel Minerva is there. And it becomes clear, my lord, if your lordship will kindly come to page 29.
Yes.
Page 29, your lordship will find just after the writings 2018 of Hotel Minerva, Panbazar. So it was the case before the Registrar of Trademark that practically, trade union, practically in support of the resolution shown to have been adopted at 3 p.m. on 12th August, there was no attendance. In fact, the attendance sheet was manipulated. That was the case projected. Now, during the course of the proceedings, my lord, in the appellate court, the labor court, my lord, the labor court passes order time and again asking them to produce the 2 proceeding books, saying that if there are 2 meetings, then naturally there has to be 2 proceeding books. Please produce the proceeding book. Now, I'll just share this to your lordship, my lord, the copies of the orders, my lord, that the learned labor court has passed. Your lordship will just see it, my lord. Page 11, my lord, last paragraph. Accordingly, appellant, has your lordship got it, my lord? Accordingly, appellant is directed to file evidence on affidavit of remaining witnesses along with all relevant documents, including the original proceeding books of the meetings on the next date. Now, they are required to file the proceeding book. Well, check next order is also passed by the Honorable Court. It doesn't come. Now, page 13 is the petition filed by them before the Learned Labour Court. In page 13, first paragraph, your Lordship will see, they say, today is the date fixed for filing of evidence of appellant so-and-so and submit the all relevant documents, including the original proceeding books of the meeting. Has your Lordship seen that, Miller? Same petition, Miller, they keep on repeating, file repeatedly, they keep on filing. Lastly, at page 15, Miller, the Honorable Court takes a little strict turn and asks them to comply it with by some time. Then they come up with this petition, which your Lordship will find at page 17. Of course, Miller, it is not marked. There, Miller, for the first time in paragraph 3, Miller, they say that the appellants further beg to submit that they had already submitted the minutes of the resolution dated so-and-so, which is the only document recording the resolution to apply for registration of Trade Unions Act. No other proceeding book recording such resolution is available with the appellant other than the minutes of the meeting resolution dated so-and-so. Now, so long, Miller, they have been maintaining a stand before the court that there are two resolutions and two proceeding books. In fact, Miller, in first of the two petitions, they also admit that give us some time, we will produce it. Now, when the Miller, the court catches hold of the mischief, Miller, then they file, this is the last petition they filed before the Learned Labour Court, that there are no other proceeding book, there is only one proceeding. Miller, in my respectful submission, Miller, this statement is enough to infer the mischief that they have been playing with the court. And basically, Miller, this is the ground on which, Miller, the Learned Registrar of Trade Union cancelled the this thing, the license, because of the fact that the application itself was manipulated. You have shown some attendance sheet and some resolution which do not go hand in hand. The resolution that you project to have adopted at 3 p.m. on 12th August, in support of that, no attendance sheet is submitted. Rather, you have submitted the attendance sheet, which is in respect of a different resolution. That resolution was to go for a registration under Societies Act, not under the Trade Unions Act. This is the manipulation and forgery that they have committed. And in both the attendance sheet, Miller, of course, Miller, there is only one attendance sheet that is available to us, Miller. The person who is the private respondent here added, Miller, his signature is only at one place, serial number 4. In all the pages. It cannot be the case that you had adopted two resolutions, there were two meetings. If that had been the case, Miller, there naturally would have been two proceeding books. That is my respectful submission, Miller. It's a clear, open and shut case, Miller, where the mischief played by the applicant, the appellant union, Miller, that is staring at the face. And one submission, Miller, if your Lordship permits, Miller, if, regarding the exercise of 227 jurisdiction, Miller, I can just place a very recent decision, only 4 paragraphs. It is not a case, Miller, where if it is an illegal order even, you cannot exercise, invoke the jurisdiction of the Honorable High Court in 227 in the guise of an appeal. What they now contend to urge before your Lordship, Miller, in my respectful submission, Miller, these can be grounds of appeal, not grounds of a revision under 227.
But also we are not getting the
exactly. Now, therefore, the question comes that in order to succeed to have an interim order in their favor, they must show a prima facie case. The balance of convenience.
That is well said.
Yes. So in a case, Miller, where it is apparently visible that there is not even an iota of prima facie case, which the Learned Labour Court has gone into and decided. Now, in the name of maintaining an interim order, what you want to do is that you want to carry the tag of a registered trade union for your business purposes, whether that can be justified. Clearly, when your registration has been cancelled because of the fraud played by you, And there is the fact that there is an element of fraud, that is, my lord, glaringly apparent on the record. Now, in such a scenario where the outcome of the grant of license is based on fraudulent activities, whether they can insist for an interim order so as to carry on the tag of the license with their name. And what will befall on them, my lord, even if the license is not there, even if the validity of the license is not there, my lord, they will not lose their membership of their parent body. Because the parent body is a registered society, it is not a trade union. Parent body is a society, registered society. So merely because the license is suspended or the license is cancelled, that will not result to their termination of their membership. Therefore, the question of suffering some loss and injury is also not.
Exactly, that was the argument advanced by the counsel for the on that day. And considering that aspect, that interim was done.
No,
On
that,
day,
my lord, if that was the submission, my lord, I was not present on that day, my lord, naturally. So, if that was the submission, my lord, then it requires a consideration whether it can be a valid argument in their favor. Because if their contention is that because of the suspension of the license, we will also lose the membership. Now, then it has to be tested whether it can be a valid argument or not. I can understand, my lord, had they been a member of a national trade union, had the parent body been a registered trade union itself, then possibly there could have been some impact. You are a society. It has got, Manal, today I am forming a society, anybody and everybody can become a member of society subject to fulfillment of the rules and regulations of the society. And it is not a requirement of law that one has to become a trade union member or one has to become a trade union. To become a member of a society, my lord, it is not necessary that one has to become a trade union member.
okay.
That is my case. And if your lordship permits, my lord, just a reference to that judgment.
We will hear on that point the main thing.
As your lordship.
Yes, Mr. Dekka.
My lord, that is precisely what I wanted to indicate, my lord. If in the IA your lordship decides whether I am entitled to a stay or not, what is left to be decided in the CRP, my lord? Because that is the precise question, my lord. That whether I am entitled to a stay during the course of the appeal proceeding, my lord. My lord, if that main question is decided in the IA, then nothing survives in the CRP, my lord. So if your lordship wants to hear the CRP, my lord, I can address all the points that have been argued so far, my lord. But insofar as the IA is concerned, IA is for removal, vacation of the stay, my lord. So ultimately, I am left with no stay, which is the civil revision petition in fact itself becomes infructuous, because if your lordship says that my conduct has been such that I am not even entitled to an equitable relief of stay, as has been argued by my friends, that my conduct is shrouded with fraud, etc., etc. If your lordship returns that finding, either way, whether it is good or bad, ultimately it tantamounts to deciding the civil revision petition itself. So my first submission would be either your lordship can hear the entire thing or close the IA for now and let it leave it to be decided along with the revision petition, my lord. Because otherwise that is the main issue. Nothing will survive. Now, my lord, insofar it is not as simple as has been sought to be projected, my lord. Submissions have been made that it's an open and shut case of fraud. I have no case at all. My interim should be vacated. In fact, my appeal is not even tenable. Precisely, that's the opposite what this court had held on the earlier occasion. That all these questions cannot be decided here or without a trial. This will require evidence. If I may draw your lordship's attention to those portions, my lord, page 144.
CRP?
In the CRP, my lord. 147 onward.
Yes.
Paragraph 22 towards the end, my lord. First, I will not trouble your lordship with the other observation that registrar cannot mechanically, at the instance of some third party, cancel it. Those were the prima facie observations.
In para 22, what is included within the purview of section 10 is only an act of fraud or of mistake or fraud committed by the trade union applying for registration. The act granting registration by mistake may occur to incorrect assessment or non-application of mind or mechanical act in the part of the registrar, but such act cannot be rectified under section 10. It can only be rectified either by the appellate authority or writ court as the circumstances may demand. The fraud or mistake. The fraud or mistake referred to under section 10 is required to be established and proved as any other fact. The factum of fraud or mistake is essentially a question of fact which needs to be established by leading positive evidence. If the trade union obtains certificate either by mistake or fraud, and if it is proved by cogent and reliable evidence, then such certificate can alone be a subject matter of cancellation. In other words, any mistake in granting registration certificate of the registrar is not within the ambit of section 10. Now at para 31, my lord, at page 151. Last but 3 lines, my lord. As I have already stated, that the factum of fraud or mistake is essentially a question of fact which needs to be established by leading positive evidence. Thus, when a tribunal exercises jurisdiction or acts in a manner which appears to be against the principles of natural justice, then the High Court can exercise its power of superintendence, and hence there is no bar to interfere with the order of the Labour Court while rejecting the prayer of the petitioner to adduce evidence in the case. So on an earlier occasion, this court has already held that these are complicated questions of fact and it has to be established by way of evidence, and therefore the tribunal is wrong to summarily arrive at such findings, and therefore there should be a full-drawn trial. After this order, my lord, I do not understand how that argument is made that fraud, it's an open-shut case of fraud, my lord. In fact, that was not even the impugned order, my lord. We'll find at page 160. I again pause here for a moment, my lord. If your lordship offers any findings on my arguments, either this way or that way, want to prejudice either of the sides, my lord. So may I pray the revision itself should be taken for disposal.
In fact, my lord, that's a fair submission. In fact, without deciding these things in piecemeal, my lord, your lordship finally decides this here.
Then I will address from the beginning, my lord. Now, before that, I'll just take your lordship to the order impugned. Page 166, if your lordship takes.
Yes.
Situated does, the third paragraph.
Yes.
Situated does. Situated does, before considering the submissions of the appellant petitioner, the moot question involved in this petition for injunction appears to be main issues and disputes involved in the main appeal, which require proper and meticulous scrutiny of documents and evidences of witnesses. Considering the nature of the dispute and the pleadings of both sides discloses many mixed questions of fact which require proper adjudication in the original appeal, appeal number 1 of 23, on proper appreciation of evidence and personal appearances of the witness by both sides, as there are names of many vital persons involved in connection with the order dated 38/23. Till here, the Labour Court is echoing with the observations of this court. This is required trial. 11. Therefore, considering all aspects, this court is of the considered opinion that without proper examination of witnesses involved in the main appeal, further extension of stay order, injunction order would cause undue delay in conducting expeditious trial of the appeal. Hence, considering all of the above, stay order is vacated. Malad, can that be a reasoning, Malad? The Labour Court says all these are questions of fact. I will decide it in the main appeal. But it vacates the stay on the ground that since this will require time, therefore I will not grant you stay, Malad. This, in my respectful understanding, is not the parameters under which a stay. Had the court said, like my friends have suggested, that I failed to make out a prima facie case, that there was no balance of convenience or irreparable loss, and therefore I'm rejecting the stay. I would have understood, my lord. Now, altogether an alien ground that the trial will take a lot of time, therefore I will sacrifice an interim order. My lord, this dehors in my, with utmost respect, my lord, this dehors logic, my lord. The interim order cannot be vacated or continued, keeping in mind whether the trial would be expeditious or not. That is an alien consideration, my lord, which therefore your lordships can interfere even under Article 227, 115 anywhere, my lord. Now coming to the facts, my lord.
One thing consideration.
Yes, my lord. My lord, we'll see the, I'll read from 165. All the issues have been dealt with, but that is the conclusion, my lord. It says about equitable relief also, but it doesn't say that I have come without equity, my lord. The paragraph above that, my lord. Let me begin with 165, my lord. We'll begin from 164, my lord. That's where the start. But I may be wrong, my lord. This is the only reasoning that I found insofar as interim prayer is concerned. At this stage, para 6, my lord. At this stage, without discussing the merit of the matter, the court, before passing any order of injunction, is duty bound to discuss principles of granting injunction. At the very outset, let us carefully examine the documents available on record, as well as the contents of the injunction petition and stay petition filed by the parties. While perusing the documents and during hearing, it has been observed by the court that the petitioner appellant has raised an issue against the respondent, and that in spite of all complaints raised against the petitioner appellant were found to be meritless, and the matter ended there. The respondent suddenly on 12/5/23 issued a show cause notice under 10B of the Trade Unions Act for cancellation of the certificate of registration. And by the impugned order dated 38/23, in the respondent cancelled the registration of the petitioner. In contradiction to the statements made by the appellant petitioner, the respondent opposite party has vehemently denied the points by submitting that a mere examination of the minutes of the meetings purportedly held on 12/8/18 clearly shows the fraud committed by the appellant petitioner. It is also stated by the respondent opposite parties that in the meantime, in the meeting, minutes of the meeting, it appears that the secretary of the association is one Dilip Chandra Goswami, and the person applied for registration under the Trade Unions Act on 27/2/19. However, in the meantime, however, in the meeting dated 12/8/2018, submitted before the registrar of firm, the secretary of the association appears to be Jitu Bormon, who applied for registration on so-and-so on the basis of that resolution, and an association cannot project two different secretaries appointed elected in one meeting. The appellant petitioner, amongst many points in his injunction petition, has mainly stressed on the point that the appellant petitioner is a representative of the state Assam, ordinary member of the All India Organization of Chemists and Druggists, and that membership of the organization required a registration. Thus, if the cancellation is given effect to, there is possibility that the same may lead to cessation of petitioner's appellant's membership in the national body. The respondent opposite party in his reply submitted that the requirement of registration for enrollment as ordinary member of the All India so-and-so does not entitle the appellant to obtain registration by fraudulent means under the Trade Unions Act. From a perusal of the case record reveals that wide order dated so-and-so, this court was pleased to grant an order of stay in favor of the petitioner, considering the urgency to take part in the so-and-so election process of the National Trade Union. All other points as contended in the injunction applied. A meticulous scrutiny of the documents available on record, such as the minutes of the meeting, there so-and-so involving signatures who attended the meeting, were yet to be physically examined as witnesses in the main appeal. Furthermore, the petitioner appellant is yet to adduce evidence on affidavit on all other vital documents, such as original proceeding book of the meeting held with the minutes of the meeting, in order to establish his claim and to prove legality and validity of the documents. That apart, injunction is an equitable remedy and shall be granted if the right is protected. Protected is clear, unquestioned, substantial, and in the present case, though the court is in the initial stage of proceeding, had passed an order of injunction of the appellant petitioner, but after receipt of notice of the opposite party, has duly appeared before this court with substantial document and legitimate pleadings, and has put forward many mixed questions of law and fact with regard to validity of the claims of the petitioner, which requires proper adjudication, trial for a decision to be arrived at the court. Situated thus, then again it says that these are mixed questions of law, fact,
I will decide it during the course of the trial. However, since the trial may take a long time, I will vacate this in order of stay. That is the reasoning, if I have understood the tenor of the order correctly. So that itself is in my respectful understanding, an error of jurisdiction, warranting an interference by this court. The initial observations, I totally second them, my lord, of the learned labor court, that these cannot be decided summarily. It has to be based on facts and factual examination of evidence, etc., which this honorable court has also said on a previous occasion. Now, so the question now is that of stay. Because appeal is already pending, High Court, Labour Court, and the petitioner before your lordship are in sync that it will require evidence, etc., going into the question of fraud. These are serious allegations, I must admit, that I have manipulated documents before an authority. So that will be decided in the course of the appeal. The question before this Labour Court at that particular juncture was whether it's a stay. Now, an argument has been made that why do I even require a registration? Now, the first answer would be my affiliation or membership to the central body is secondary, my lord. This is an association of nearly 5,000 members. So, if the trade registration as a trade union is not stayed, I will be a derecognized body. And this body is representing Assam before the central body, my lord. Now, in the IA, which my learned friend had pointed out, reference was made to the association of the governing the regulation of the central body. We read out clause 3 membership. Now it was read clause 3 and it was said that membership only requires a memorandum, my lord. But unfortunately, my lord, this is not even the complete set of the constitution. They have missed that very particular page which says I need a certificate of registration. So my lord will have page 60 of our CRP, that most vital clause, that page for some reason is not a part of the constitution given by them, which is clause 7. Any association who is otherwise eligible to become page number 60. Admission of members, the right column.
Yes.
Towards the bottom, membership application shall have to be enclosed with the memorandum association along with a certificate of registration. So I have to be registered somewhere. Just 5,000 people cannot just casually go and get a membership with the national body. These are all these are association or sub-association. There's an umbrella where all states are doing it. So if this order of the trade union is not stayed, the effect of the non-grant of stay is basically we become a derecognized body altogether. And when at the moment I become a derecognized body, I'm not entitled to any of the benefits that are coming from the state, my lord. Then I'm not even given, my membership ceases with the national body. Assam goes unrepresented, etc., etc. So these are civil consequences. So that in my respectful understanding should have been the paramount consideration. That if the order is not stayed while the appeal is pending, will there be civil consequences or not? And that's the settled law, that while considering a stay, when an statutory appeal is pending, a stay normally is granted of any order which has civil consequences. And more particularly when the appeal is admitted, because these are statutory first appeal. So in fact, these orders should come as a matter of routine, in my respectful submission.
My lord, para 4, I'll not cite the entire paragraph, my lord. Somewhere in the middle, my lord, just above the dotted line, but if orders, as your lordship found it, above that dotted line, 3 lines above that, my lord, but if orders are challenged and the appeals are pending, as your lordship found it. But if orders are challenged and the appeals are pending, one cannot permit a swinging pendulum continuously taking place during the pendency of an appeal. Mr. Manoj Swarup may be wholly right in submitting that there is intentional flouting of the court's order. We are not interdicting that finding, but judicial approach requires that during the pendency of the appeal, the operation of an order having serious civil consequences must be suspended, more so when the appeal is pending, admitted. Previous history of the litigation cannot be overlooked. So, during the pendency of an appeal, we cannot be left with so much uncertainty. Rightly or wrongly, they may have passed an order. That is subject to a first appeal, a statutory remedy that I have under the Act. And if the order impugned has consequences, civil consequences, then as in all normal circumstances, if I have understood the law correctly, those orders should be stayed. And whether I will be met with civil consequences or not is the question. And that question was never even discussed or decided by the learned labor court. So that aspect of the matter, that we are a body of 5,000 members, these are the regulations that we have to comply with. If you summarily just reject the stay only on the ground that your appeal will take time, so therefore there's no requirement of a stay, we will be visited with serious civil consequences, and hence we should be, this stay should be granted. Now, my lord, lot has been said, my lord. I reserved my most of the arguments to argue before the appeal, my lord, how it's a fraud, etc., whether it's a fraud or not, my lord. But I'll just quickly answer a few arguments that were advanced. All said and done, my lord. Manipulation of records, how many members signed, where was the meeting held, was it Minerva, was it Pan Bazaar, etc., my lord. The moot argument is that since you applied for society registration first, you ought to have either disclosed before the registrar of trade union that your application is pending, and because of that pendency, you are not entitled to a certificate under the Trade Unions Act. My lord, I have posed this question to myself: is there a bar, my lord? In fact, our stand is very clear, my lord, that yes, there was difference of opinion. We applied in both the organizations, both the offices. In fact, if your lordship sees our stand at page 27, my lord, we have made candid disclosure, my lord. There is nothing to hide. Yes, we applied in both the places. Then there was, it's ultimately a society, a group of people decided, no, perhaps we should go with trade union. It is as simple as that. And we are not hiding anything. We've said we've applied, and then we withdrew also society registration. Page 27, my lord. In fact, the law is also very clear that even if you apply under society's registration, your society registration registration would go and your trade union will prevail. Will your lord? That with regard to the para 27, that with regard to the allegations that the appellant had resolved to register itself under the Societies Registration Act, it is clarified that though an application for registration under the Societies Registration Act was preferred by the appellant under a bona fide mistake, the same had been withdrawn way back in the year 2021 by addressing a letter to the Registrar of Firms and Societies. As a matter of fact, the Registrar of Firms and Societies had also provided an information under the RT Act to the effect that the appellant union is not registered under the Societies Registration Act. Initially, there was some difference of opinion amongst the members whether to obtain registration as a society or as a trade union, for which 2 separate resolutions were adopted. I'm admitting, my lord. However, it was eventually decided to pursue with the resolution adopted on 12/8/18 at 10 a.m. That is the resolution to register the organization as a trade union and after the members understood the purport of section 14, my lord. Now section 14, what does it say, my lord? They took legal advice saying that we've applied both, and they said you can't apply for both. If you apply for both, your registration under the society will go. Section 14. The following acts we are concerned, namely, A. Society Registration, Cooperative Society Companies Act, shall not apply to any registered trade union, and the registration of any such trade union under any such act shall be void. So, assuming that even if I have got society registration, by virtue of 14, society's registration would go, not my trade union registration. So these are ultimately these are pharmaceutical dealers, my lord. They don't know all of this. So they thought that let us apply for both. It was a bona fide mistake, my lord. There's nothing, no hiding from that. Now, why are they making a mountain out of this molehill is the question, and that is where perhaps the should I continue at 2 minutes? Will be.
Yes, Sir Deka.
Yes. I won't take long. So, my lord, as I had submitted, my lord, first of all,
Decision. Yes.
Decision I've already cited. So far, my lord, my submissions are, firstly, your lordship has seen the order. The consideration was not right. Secondly, these are all factual dispute as has been observed by the High Court as well as the Labour Court. So these factual dispute regarding fraud cannot be gone into at this stage. Thirdly, the only question is stay, whether I'm entitled to a stay. So relying on Moolchand, I've shown that any order, when it is admitted in an appeal, is pending consideration in an appeal. And if that order has serious civil consequences, it should ideally be stayed, my lord. What are the civil consequences here? I've already submitted, my lord. We are a huge group of individuals. We are an umbrella organization with district units, etc. So this entire body will become derecognized. And secondly, I have also shown the complete set of regulations of the central body, which requires a certificate of registration. So my membership before the central body will also go, my lord. So these civil consequences were not even gone into, that issue was never gone into by the learned Labour Court. Now coming to the allegations of fraud, etc., I've already submitted, my lord, that even if we assume that I made application at 2 places, my lord, that itself will not matter much if my documents are in order, regardless of whether I've applied for society registration or not. I may still be entitled to trade union. Now, if your lordship, a lot has been said about the resolution and the signatures, my lord. The signature sheet has also been annexed twice to project that the same 2 different resolutions. There were 2 single set of signatories, my lord. The signatures, I'm sorry. Now, if your lordship has the act for a moment, in fact, my lord, I may subject to correction, my lord. The act or the central rules does not even mandate a resolution for registration as a trade union. If your lordship sees section 5 of the act, every application for registration of the trade union shall be made to the registrar and shall be accompanied by a copy of the rules of the trade union and a statement of the following particulars: names and occupations, addresses of the members making the application. In the case of a trade union of workmen, the name, occupation, and addresses of the place of work of the members of the trade union making the application. C, the name of the trade union, address of the head office. C, the title, name, address, and occupation of the office bearers of the trade union. Where a trade union has been in existence for more than 1 year, we are not concerned. Now, the central rules should be there with your lordship in that very same act, my lord.
Now, in the Central Trade Regulations, Union Regulations 1938, Rule 3. Regulation 3, every application for registration of a trade union shall be made in Form A. Now, Form A is also appended to these regulations, my lord. I do not find any requirement of even submitting a resolution. So this entire lord, allegations, entire lord, so much harping on the fact that the resolution signatories are different, etc. In my respectful understanding, is totally inconsequential and irrelevant. I need to apply under Form A. If the documents are in order, you need to give me a registration certificate. Now, thereafter, if you have to cancel my registration under Section 10, then some sort of an fraud would be has to be shown. Just because a body applies for registration under two different acts, does it amount to a fraud, my lord? That's the question I posed to myself. And this resolution, as per the statute, is not even required. Now, the question is, ultimately, civil consequences I've already shown. The appeal is admitted. Everything will be decided in the course of the appeal. High Court has already said that the evidence should be taken stock of. Now, the question is the question of balance of prejudice coupled with the question of prejudice, my lord. Now, your lordship will kindly appreciate the fact that if a stay order is not granted, my lord, then I become a derecognized society. My members go haywire, my lord. My body becomes totally defunct. I'm deprived of all the welfare schemes of the state. See my membership before the trade union goes. These are the prejudices that I am likely to suffer. What is the prejudice the registrar of trade unions will suffer if a stay is granted, my lord? They have got nothing to do. They did not pay me money. I'm not getting any money from them. You only need to refrain from striking off my name from the register of trade union. So if you retain subsequently, if you succeed in the appeal and it is held that yes, it is fraudulent, then my name will be struck off. But if it remains for say maybe until the proceedings end, what prejudice is likely to be caused to the registrar of trade unions? No, because ultimately now it's turning out to be a contest between the registrar of trade unions and the body, my lord. It ought not to have been that way, my lord. Because they are a body, I am registered with them. They do not lose anything out of it. If I have played fraud, the appellate tribunal will see, and eventually, if I have played fraud, my registration will be struck off from the register. But what prejudice will be caused if a stay is granted until there is a final adjudication, my lord? Now that brings me to the last point, my lord, and it has consistently been my case, my lord. In fact, I have narrated the sequence of event in my application. It has got nothing to do with the registrar of trade unions, my lord. There are two rival bodies. There is a hotly contested civil suit as to who should represent Assam before the central body. I think your lordship had the occasion to deal with one of those matters, which was ADDA versus CDA. So it is actually a dispute between two bodies as to who should represent Assam before the national body. Now, first of all, 2011, they file a series of RTIs. Those are part of record. That a CDAA should not, cannot be a trade union. It is not comprising of labor. Now, why I'm saying that? Now, my lord, now after all that is done, my lord, everywhere I'm given a clean sheet. Now they fall back on this new ground that what registrations, what resolution was given way back 6 years ago.
Not necessary. Taker, all those things are we are testing the order of the
labor code.
Yes.
My lord, and lastly, my lord, I will not elaborate on that. But I was moving on to the point that the Supreme Court has also said, my lord, if there is an order passed by an authority, my lord, if there is an order passed by an authority and that order is before an appellate forum, my lord, that authority should not be overzealous to point out that the order passed by it is correct. And this is precisely what is happening, my lord. Now, registrar trade union has a sort of a sacred adjudicatory function. It has passed the order, my lord, that it is now that will be tested in the appeal. It is not for the registrar of trade unions to contest this appeal and to say that my order is right, therefore it should not even be stayed. Those were the observations made by the Supreme Court in Airports Economic Regulatory Authority, my lord. I'll refrain from pressing it. I'll just that is what I wanted to indicate is this, my lord. Registrar of Trade Union absolutely has nothing, no prejudice will be caused to them. And it is not their duty to come and defend their order before this court. Because they have passed an order, it will be tested in an appeal. Now, this is becoming too confrontational between the registrar of trade union, which is the adjudicating body, and one of the parties, which is why, while deciding whether such bodies should be impleaded in the appeal or not, the Honorable Supreme Court made observations that the authority should not come in defense of its own order. So that's never how it's meant to be. Para 16 is where it was said, my lord, it was dealing with the question whether he should be heard at all, the register. Supreme Court said, yes, in cases, the authority can be impleaded as a respondent, but the respondent, the authority as a respondent should not side with any of the parties and take a aggressive stance, my lord. That was the observation made by the courts, my lord, para 16 onwards. This era judgment, yeah. 2024 SCC Online 292.
Yes.
Para 16. The respondents referred to judgments of this court and of various high court for the proposition that statutory authorities exercising quasi-judicial functions cannot defend their orders in appeal. Before we proceed to determine if ERA is a quasi-judicial authority, it is necessary that we clarify the contours of this proposition. The judicial principle is that a judicial or quasi-judicial authority must not be impleaded as a party to an appeal against its order is premised on two reasons, both rooted in constitutional philosophy. The first reason is that with the impleadment of the judicial or quasi-judicial authorities as respondent, they will be required to justify their decision before the appellate court. This is contrary to the established principle that judges only speak through their judgments. Any dilution of this principle would lead to a situation where every judicial authority would be called upon to justify their decisions in the Court of Appeal. This would break down the entire edifice of the judicial system. Para 19, my lord, in Mohammed Omer versus so-and-so, an appeal was preferred against the order of the Registrar of Trade Unions before the High Court of Bombay. The Solicitor General of India put an appearance for the registrar. The Solicitor General submitted that he appeared to help the court by pointing out certain errors in the judgment of the lower court. The division bench of the High Court of Judicature at Bombay held that though there are certain cases in which the registrar should appear, and this is not one such case, Chief Justice Chagla, writing for the division bench, observed that the Solicitor General made a startling proposition by which the judge of the court of the first instance appears before the court of the second appeal to argue that his judgment was correct and that the judgment of the court of the first appeal was wrong. The bench observed that there may be cases in which the registrar should be a contesting respondent and the registrar acting as a court of first instance cannot appear before the second appellate court merely to point the errors in the judgment of the court of first appeal. The second reason for this principle is that impleadment of judicial authority as a respondent would contravene one of the primary tenets of natural justice, that an adjudicating authority must not be biased. It is in deviation of the principle that an authority exercising adjudicatory function is required to be a neutral arbitrator, which does not have personal interest in the matter. And it goes on and on. So the proposition I'm trying to canvass is this, my lord, that ultimately they have passed an order. It will be tested in the appeal, my lord. Now to contest it as a contesting respondent to file stay vacating applications to say, to sort of explain how the initial order was right or wrong is not the function of that adjudicating body, my lord. Whatever is required to be done will be done by the appellate court, my lord. And now only thing is, will stay of the cancellation of registration during the pendency of appeal
will cause any prejudice to them, should the cancellation order be allowed to take effect when there is a statutory appeal already pending and admitted, my lord? And thirdly, what are the consequences that are likely to befall me, and where is the balance of convenience or the test of prejudice, my lord? Now, with utmost respect, the Labour Court had not applied these principles while granting the stay, my lord. Therefore, it's a fit case to be interfered under Article 227.
But please allow. My lord, I'll be answering all the arguments. First, my lord, there's a submission made that there is no requirement of submitting any resolution. Now, I'm giving the format of the Assam rules, and I have the record, but today I don't have, but I can place it before a lordship. Lordship will see that a resolution is a must, that we decide to form an union. This is the formation application form under the Trade Union Act, Assam rules. Now, point 8, we have been duly authorized to make this application by a resolution number so and so, adopted unanimously in the general meeting of workers held on. So, the requirement of submitting a resolution for registration is a requirement. That is why they had in fact submitted this resolution. Now, my lord, another aspect. Now, then argument has been advanced that we had resolved earlier to register under the Societies Registration Act. That was not done. Then we approach here. If your lordship takes up section 15, now if their real intention, or had they really resolved to register themselves as a trade union, this section 14 is very clear. A trade union cannot be registered under the Societies Registration Act. If the original resolution was to register the association under the Trade Unions Act, then they could not have applied before the Societies Registration Act. Section 14 is very clear. Certain acts do not apply to registered trade unions. The following acts so and so shall not apply to a registered trade union, and the registration of any such trade union under the act shall be void. So, if you have resolved to form a trade union, then your application to the Register of Society is void. So, you have applied there and you have not disclosed that fact. It is only after the registration under the Trade Unions Act was given in the year 2019, you had withdrawn it in the year 2021. So, the intention was very clear to register it. Even their constitution says they are a society. I have taken your lordships to that particular annexure where it shows that their society, they are claiming themselves to be a society, the constitution, which your lordship will see. At page 31 of my IA. This is the constitution. They have resolved. Now it is at page 31, the name of the society, Chemist and Druggist Association of us. If you have a constitution which says you are a society, how come you claim yourself to be a trade union and get yourself registered under the Trade Union Act by manipulating the document? Now, my lord may have a look at their parent bodies, which your lordship will find at page 53. The parent body, page 57 of the CRP, the parent body is a registered society, and the membership says each member will have to submit their registered memorandum. at page 58. And at page 60, it says the membership application shall have to be enclosed with memorandum of the applicant state association along with the certificate of registration. Now, it is the certificate of registration of the memorandum of association which is required to be submitted for being a member. It is not required that the member should be a registered trade union. Where is the requirement that the membership, to be a member of the parent body, it has to be a registered trade union? It is not there. So it is a registered memorandum, and a certificate of registration of the memorandum is sufficient. So they are projecting that on one side they are the member of this association, which is a registered society, and they are registering themselves under the Trade Union Act. Two acts are completely different. Trade Union Act is an act which was enacted to resolve trade disputes. So their own parent bodies memorandum says that you have to be you have to have a registered memorandum. You need not be a registered trade union. Now, even in the earlier interim order, the reason for passing it or giving some protection was on the ground that they should be able to participate in a trade union meet. It was completely on a wrong premise. They were never connected with any trade union meet. It is their own case that they had a meeting of their parent body, which is a registered.
To the point of the order of the.
My lord, I am coming to that. Now, if your lordship comes to the order, the court has taken note of the fact that it is interim order is not a matter of right. That in every case, wherever there is an appeal filed, one should get an interim order. It is an equitable relief. Based on the fact that a prima facie case is made out for grant of an interim order. Now, if your lordship starts reading from page 165, 64, at page 65, it is at the fifth line from the top. It is also stated by the respondent parties that in the minutes of the meeting dated so and so, it appears that the secretary of the association is one Dilip Chandra Goswami, and that person had applied for registration of the Trade Union Act under Trade Union Act on 27/2/19, and however in the meeting dated 12/8/2018 submitted before the Register of Societies, the secretary of the association appears to be Mr. Jintu Bormon. Now, my lord, I'd like to draw your lordship's attention to this fact. Now, you, in one meeting, you resolve to appoint Mr. Jitu Bormon as a secretary. On the same day, you adopt a resolution to make another person the secretary. And this Jitu Bormon applies under the Society Registration Act. Now, this is what the learned quote below. An injunction is an equitable relief and shall be granted if the right being protected is clear, unquestioned, and substantial. And in the present case, though the court is in the initial stage of the proceeding, I passed an interim injunction in favor of the appellant petitioner, but after receipt of the notice of the opposite party has duly appeared before the court, substantial document, legitimate pleadings, and put forward some mixed question of law. So here the learned court is questioning whether he has a substantial right for an interim order. That is, whether he could make out a prima facie case that yes, we had two different meetings and this is how the thing projected. Now, so the court, the learned court below is questioning his right for an interim order stay on the basis of making out a prima facie case. Because your lordship has already seen, in spite of several opportunities, even I'm making a submission before this honorable court that if they can produce both the minors before your lordship also, the matter ends. Nothing will be left for decision. Now the question is, if someone has obtained a certificate of registration by fraud and that has been cancelled by the authority in compliance of the provisions of the Act, whether that person is entitled to have an interim stay as a matter of right. Now that judgment that it in cases having civil consequences in a pending appeal, all proceedings should be stayed is not to be applied in all cases. It depends on the facts and circumstances of each case. It is not a ratio overlooking the three important aspects of injunction: prima facie case, balance of convenience, and irreparable loss. That decision was given in the facts and circumstances of that case, and it doesn't apply universally in all cases. Now, lordship will appreciate one thing: interim order or an interim stay injunction is a discretion. It is not a matter of right. The tribunal or the labor court, for reasons recorded in the order, is of the opinion that no prima facie case could be made. Although it is not written in so many words, but if your lordship goes to this paragraph, an injunction is an equitable remedy and shall be granted if the right being protected is clear, unquestioned, and substantial. So, their right for an interim order is very clear. So, what the learned court below tried to project is that if the interim order is continued, then it would amount to granting of final relief, because it has to be decided. Grant of an interim order will have to be decided after examining all questions, because the petitioner could not make out a prima facie case. Now, my lord, the argument that Register of Trade Union should not contest this case. On one hand, their argument is it is a civil suit where parties should lead evidence. Now, if the Register of Trade Union does not contest the appeal or doesn't come up with any stand, whatever case they will project will go unrebutted. Who will be there to find out? In that case, there is no requirement of leading evidence. Whatever record is there, the record will speak. That is why the initial objection from the part of the Register of Trade Union was that there should not be any evidence. Whatever record is there, the appellate court should decide on the basis of the record. There, at that time they said, no, it is a civil court. Parties should be given the opportunity to lead evidence. On that ground, the matter came before the High Court, and this Honorable High Court has remanded the matter for recording evidence. Now, if the Register of Trade Union does not contest the appeal, whatever evidence they will lead, it will be an ex parte evidence. There will be no one to say, okay, so that they are leading fair evidence. Now, this question requires an answer from this honorable court is whether a stay is a matter of right in every case. My lord, I'd like to rely on some decisions. I'm giving them, I'll not take much time, I'm just giving the photocopies. In matters relating to the exercise of power by this honorable court under 227 in matters of decision by the tribunal. Now, in 1998, in this 1998 1 SCC 633, paragraph 14, I'm reading just paragraph 14. A reading of the order of the High Court will show that it has substituted its view in the place of the view taken by the statutory authority, which is not within the jurisdiction of High Court. Lordship may come to paragraph 14. A reading of the order of the High Court will show that it has substituted its view in the place of the view taken by the statutory authority, which is not within the jurisdiction of the High Court while exercising power under Article 227 of the Constitution of India. Apart from above, it is now an admitted fact that the alleged acquisition initiated in the 1987 must be deemed to have been either given up. So this is on the facts and circumstances, but here the law is High Court should not substitute the view taken by the now another decision, my lord. Two 2001 8 SCC, I will refer paragraph 6 and 7. 2001 8 SCC 97. 6 and 7 paragraph. The scope and ambit of exercise of power and jurisdiction by a High Court under 227 is examined and explained in a number of decisions of this court. The exercise of power under this article involves the duty on the High Court to keep inferior courts and tribunals within the bounds of their authority and to see that they do the duty expected or required of them in a legal manner. The High Court is not vested with any unlimited prerogative to correct all kinds of hardship or wrong decisions made within the limits of the jurisdiction of the subordinate courts or tribunals. Exercise of this power and interfering with the orders of the court or tribunal is restricted to cases of serious dereliction of duty and flagrant violation of fundamental principles of law or justice, where if the High Court does not interfere, a grave injustice remains uncorrected. It is also well settled that the High Court, while acting under this article, cannot exercise his power as an appellate court or substitutes his own judgment in place of that of the subordinate court to correct an error which is not apparent on the face of the record. The High Court can set aside or ignore the findings of fact of an inferior court or tribunal if there is no evidence at all to justify or the finding is so perverse that no reasonable person can possibly come to such conclusion, which the court or tribunal.
These are well settled principles.
My lord. So, my lord, here is a case where the tribunal has exercised its discretion not to continue with the interim order which was obtained ex parte and based on our objection and placing of materials on record.
Okay. That's okay. What paper does
Only 1 minute. I'll just certain actual aspect I think I need to point out to your lordship. First of all, my lord, the submission, it has been already repeated by my learned friend, that the requirement of filing the resolution is in the state rules. Assam state has its separate set of rules under the Act, and the copy that my learned friend has submitted to your lordship, my lord, this is the form prescribed with the state of Assam. And that is the reason, my lord, they had also submitted the resolution. And in that resolution, it is requirement that one should make a declaration that it has been resolved by us by so many numbers, so in resolution number so and so, and that is how it goes before the registrar. Now, since there is a dispute between the two resolutions, naturally the registrar called for an inquiry, called for an answer. And this section 10 of the Act also authorizes the registrar to cancel the registration if it has been obtained by fraud. If the registrar is of the opinion that the registration has been taken by fraud, then he can cancel it. So to satisfy himself, my lord, the registrar had called for them, submit the two proceedings or the two resolutions that you have adopted. Well, that they failed and therefore the cancellation was done. So far as the requirement of submitting the resolution is concerned, it is spelled out there. Now, the moot question before your lordship, my lord, in my respectful submission, is whether the interim order, impugned order passed by the learned tribunal is within the bounds of law or not. If your lordship forms an opinion that the impugned order passed by the learned tribunal, refusing to extend the interim order, is within the bounds of law, then my lord, the matter ends. And if it not, then your lordship intervenes. Now, my respectful submission is that the learned tribunal has tested the situation on all the three parameters. Of course, my lord, I must also admit that it has not been written in so many words. But if your lordship reads the entire order, the last two lines have to be understood in the context of the entire order. In the entire order, my lord, the prima facie case has also been considered. Balance of consideration, balance of irreparable convenience has also been considered. Now, a projection has been made by the appellant's petitioner's side that, referring to page 58 and particularly page 60 of the CRP, my lord, that page 60 requires that there has to be a certificate of registration. Now, this registration, my lord, in my understanding, and as also has been pointed out by my learned friend Mr. Chakraborty, this registration is with regard to the registration of the memorandum, not the registration of the union. Because if a body is already registered as an union, there is no further requirement of it becoming again a society under the Societies Act. And this is very important because of the fact, my lord, section 14 of the Trade Union Act says, I'll just read it again. My learned friend has also showed it. The following acts, namely Societies Registration Act and others, shall not apply to any registered trade union and the registration of any such trade union under any such act shall be void. Now, if you are a trade union, then whatever requirement you are imagining or you are conceiving at the page 56, 58 or 60, well, their parent body is a society. If we go by the mandate of section 40, whatever be the society, my lord, their working and functioning cannot influence them, because the act says that the Societies Registration Act shall not apply. Now, even if, my lord, for the sake of argument, I assume that there is a requirement of a kind, my lord, as has been projected by the petitioner, my lord, that cannot have an overriding effect on the affairs of a trade union. Therefore, to say that the moment the certificate is cancelled, I'll lose my membership and 5,000 people under my banner will be decategorized, that is far from being the reality. Because the requirement under the Societies Registration Act is not that you apply you be a member of trade union, because it cannot be because of the statutory bar. So, to project that, to continue as a member of the parent body, we need to continue as a trade union. Well, that is not correct. In my respectful submission, well, if I have been able to convey my submission below. The society, your parent body only requires you to have a certificate of your registration. What is registration? Certificate of your memorandum of association. Your parent body cannot require you to become a member of trade union because of the apparent bar in section 14. Because section 14 says that this will not apply to trade union. The Societies Registration Act. So, to contend that in order to continue to become a member of the society of which we are a member, we need to continue as a trade union. That is fundamentally that will be a wrong submission, my lord, in my respectful submission. The second aspect is that my lord, the page 86, your lordship will kindly see. What was the occasion for the Honorable Labour Court to pass the interim order? Page 86, last paragraph. Before going to pass an order on merit of the appeal, I am of the view that considering urgency of the situation, as the appellants are to take part in the ensuing election process of the National Trade Union meet. That was the consideration. They projected an urgency that there is a National Trade Union meet in which we also should take part. Therefore, unless my license is not protected, our license is not protected, we will be deprived. That eventuality or that contingency is lost now. That is all over. To protect their interest in that circumstance, my lord, the interim order was granted. And thereafter, my lord, the Honorable Court has found that neither these paramount importance, matter of paramount importance, which is their participation in a meet is concerned, that is not existing, nor their process of coming as as a trade union is also very clean. Now, as I have in the previous part of the day, my lord, as I have shown, the court has been very consistently asking them to produce the books. At one point of time, they were also suggesting that there are 2 books which they will produce in course of evidence. And now it has come from their side only that there are no 2 proceeding books. That is, there is only 1 proceeding book. If that is the case, my lord, my respectful submission is that their case of their having a prima facie case, my lord, is lost. And if any of the 3 out of the 3 considerations, my lord, if any one of them is missing, my lord, then it will not be a case for grant of an interim order. And today, if the interim order is not continued, my lord, which by virtue of the order of this Honorable Court, they are enjoying, my lord, nothing is, no civil consequence, my lord, it has been argued before your lordship that it will entail serious civil consequences. No civil consequences is going to, because even if we go by the memorandum of association that they have annexed at page 56, it does not say that merely because you cease to become a trade union, you lose our membership. In fact, they cannot say it at all. As a society, my lord, it cannot be a condition precedent that you should become a member of trade union. Because the section 14 will come in between. Section 14 prohibits application of society's registration. So therefore, this submission that if the interim order is not there, will be in a dire straits, that will be far from reality. This is my one submission on their irreparable loss. Another point that I need to address to your lordship is that, my lord, my learned friend has said that since there is an appeal, there has to be an order stay. My lord, that grant of an order of interim stay is not automatic. Regardless of the forum, my lord, even when your lordships are exercising 226 jurisdiction, my lord, the prima facie test is this: balance of convenience, irreparable loss and injury, and prima facie case. Otherwise, the interim orders are not granted. So here is also a case, my lord, it is not done. And the judgment that I thought I will be showing to your lordship, my lord, these are all comments in sum and substance, my lord, these are all no, but it's a very recent judgment, that's why I am showing it. Only 4 paragraphs, your lordship may note. From paragraph 16 to 20. Now, if your lordship will kindly turn to paragraph 16.
Yeah.
Well, the previous 5-judge constitution bench decision has been referred, and this has been sounded again, my lord. It is settled law that power of judicial superintendence must be exercised sparingly to keep subordinate courts and tribunals within the limits of their authority. When a tribunal has acted within its jurisdiction, the High Court does not interfere in exercise of its extraordinary writ jurisdiction unless there is grave miscarriage of justice or flagrant violation of law. Jurisdiction under 227 cannot be exercised in the cloak of an appeal in disguise. What they are, in my submission, my lord, what they are trying to convince your lordship in a manner, my lord, as if, normally, my lord, an order refusing injunction is an appealable order under the CPC also. What they are trying to get from your lordship, my lord, is an appellate consideration of the judge of the order passed by the learned Labour Court. It is not a true, my lord, if the tribunal is having a jurisdiction to decide a matter in a particular manner, the tribunal has a jurisdiction to refuse interim relief. Thereby, it cannot be said that the tribunal has exceeded jurisdiction. Yes, if it can be shown that the tribunal, while passing the particular order, has acted in such a manner which is not conceived of under any domain of law, my lord, then possibly, my lord, 227 interference is justified. Here, the tribunal had being seized of the matter, my lord, applied its mind, took into consideration the relevant aspects, and thereafter returned a finding that there is no necessity of further continuation of interim order. In my respectable submission, my lord, that there is no palpable wrong caused in that manner so as to interfere, so as to invite your lordship's interference under 227. One more sentence that has been recorded here is this, Miller. In paragraph 18, your lordship will kindly see. It is not the respondent's submission that they were not given an opportunity of being heard by the civil court. Such opportunity having been given, even if the conclusion arrived at by the civil court was erroneous. My learned friend has submitted that the impugned order suffers from an error of law because it has been premised on a consideration that the grant of the interim order will delay the trial, my lord. So, such consideration is erroneous, my lord. That was the submission made. The Honorable Court says such opportunity having been given, even if the conclusion arrived at by the civil court was erroneous, it could not be remedied by the High Court in exercise of its powers under Article 227. As was held by this court in so-and-so versus so-and-so, a mere wrong decision is not enough to attract the jurisdiction of the High Court under Article 227. Thus, the petition of the respondents also failed to merit the exercise of the High Court supervisory powers and should have been rejected in view of the same. So, unless some grave injustice having been caused or being caused, I can understand, Miller, tomorrow they say that because of the cancellation of the registration, we are also a trade union, our parent body is also a trade union. To continue as a member of the trade union parent body, we need to be a trade union. Cancellation will also entail cancellation. Had it been a case like that, Miller, perfectly all right. Your parent body is not a trade union, and under the Trade Unions Act, you cannot have a registration of trade union as a qualifying measure to become a member of a society, because two acts are coming in conflict with each other. So, to say that by not suspending the cancellation will amount to cancellation of their membership, that is not correct. And ultimately, my lord, it's a case where they want to inject life into a dead body so as to have it in continuity until the appeal is decided. Your termination, your order of cancellation has been passed by giving you an opportunity. Now, whether that opportunity was adequate or not, well, for that matter, they have a grievance, they have filed the appeal, it will be hard. Now, that does not mean that in the interregnum, their license, their registration has to be revived. It will amount to revival of their entire claim, granting them final relief, which they may not be entitled at the final end. Tomorrow, my lord, if the trial court returns a finding that in fact, and based on their, correspondences, if the tribunal returns a finding that in fact, my lord, it was obtained by fraud, then what happens if the activities that they will carry in the interregnum because of the interim order, what will happen to that? It will be amounting to perpetuating an illegality. So therefore, my lord, in my respectful submission, there is no wrong in the order which warrants your lordship's intervention under 227.
Well, just one thing I would like to point out. If your lordship takes up page 31 of my IA, lordship will see the object of the association.
I have already put
No, here I have pointed out that the first thing, if your lordship takes up page 31, clause number 6, what is the objective with which this association is formed? Now, all these objectives are not related to any trade union activities. Some are to provide health facilities or disease employee of the society, against society.
we are not discussing the legality or illegality of that. Okay. Third, Mr. Teka, third and fourth.
One.
Then, third. Third. Or two. Order is that.
Obliged.
Like